Welcome to Part 2 of the Healthcare Transition Training for Healthcare Professionals. This section of the course includes Modules 6 through 10. Before beginning Module 6, let's review the learning objectives for the course as a whole. Part 1 addressed important concepts in the healthcare transition process. Part 2 examines key activities to address before the care transfer. Let's begin Module 6, Legal and Financial Considerations During Transition. By the end of this module, you will be able to list legal rights and responsibilities conferred at age 18, describe programs that address legal and financial needs, and address legal and financial considerations in transition plans. Reviewing coming rights and responsibilities reinforces the idea for all involved that at age 18 the patient will be an adult. When adolescents turn 18, they gain their legal rights as adults. The 18-year-old also gains new responsibilities. These include obligations to the government, such as for jury duty, and for financial decisions, such as debt repayment. All rights previously accorded to the parents under IDEA transfer to the student upon their 18th birthday. The school district must notify the student and the parent 1 year prior to the transfer of rights. Patients gain medical rights immediately and automatically on their 18th birthday. Parents have no right to their child's medical records or to make medical decisions on their behalf after age 18. Healthcare professionals cannot provide confidential information to parents without written authorization from the patient. HIPAA has heightened the awareness of healthcare facilities and providers about confidentiality. It imposes severe penalties for inappropriate sharing of personal health information. The Florida Bar Association provides a pamphlet for young adults about their new legal rights and responsibilities. It is available in full on their website to view or to download as a PDF. The next 3 sections present ways to address legal and financial considerations. The first program is the Florida Department of Vocational Rehabilitation Program, or VR. VR's mission is to help people with disabilities find and maintain employment and enhance their independence. They administer several programs to achieve this goal. VR's School to Work Transition program offers a number of activities that prepare students for training and/or work after they leave high school. Anyone can refer a patient for VR services by calling the numbers on the screen. Schools generally take the lead in referring students with an IEP at age 16. If the family does not have an IEP in place, discuss a referral to VR during their middle adolescence transition plans. Florida VR operates under a prioritization methodology called the Order of Selection. Federal rules require that when a program cannot serve every eligible individual who applies due to resource constraints, it must prioritize services to individuals with the most significant barriers to employment. Even if there is a waiting list at the time of application, it is important to apply. People are released from the waiting list according to their application date. The sooner applied, the sooner received. The Florida HATS Transition to Go fact sheet on VR provides a 1-page summary of this module's vocational rehab section. It also includes links to various VR programs, applications, and eligibility information. Provide the patient with this tool as a part of their transition plan. The issue of guardianship is a complicated one. Acknowledge the emotional difficulty that families face during such proceedings. This section of the presentation provides concrete information for the guardianship process.
A lot of parents come to me and they say, now my child is 18 and everything is going great and we're not experiencing any barriers to medical issues or financial issues. There are other parents that say, you know what, we're having some problems. They might be problems in accessing financial information or healthcare information, and they ask, where do I turn? At that point, obviously, it would be to have them start speaking to an attorney. I have a lot of families and they ask, you know, what should I do? Should I just do nothing and let my son or daughter be the self-advocate? Should we talk about healthcare powers of attorney, you know, so I can be involved? Or guardianship. As a parent, my answer is whatever it takes to make sure that, in my perspective, that my daughter is safe, that she's not taking advantage of, that she's getting the care that she needs. Those principles usually are what guide families in deciding what it is that they feel might be best. When we're looking at different means of assisting our adults with decision making, it's important to remember that we shouldn't be putting too many things in place when our ultimate goal is to have our son or daughter be able to be as self-determined as possible. Everyone makes mistakes. You know, we learn from them, we grow from them. And it's important for parents to remember that we need to also allow our sons and daughters to make mistakes and learn and grow from them as well. If the individual, when they turn 18 or the age of majority in their state, would like to have parents or other family members assist them with either medical decisions or financial decisions, they could actually go to an attorney and have what are called powers of attorney drafted. Power of attorney is a legal document where someone could give a financial power to someone else to assist them with their financial decision making, or medical power to assist them with their medical decision making. An attorney would need to feel comfortable that the individual who was signing these documents actually understood what it was that they were signing, because they are giving these powers to someone else to assist them. As we know, we're our kids' guardians until they're 18. But at that 18th birthday, guardianship is another option that some families are looking at. They would like to continue being the guardian of their son or their daughter, or perhaps also being a guardian of the assets, and they're two different things. That process is initiated in a court. If I, as a parent, were looking to seek guardianship over my son or daughter or other family member, I would petition the court to become a guardian of the person or the assets. Keep in mind, if you do become the guardian of someone's assets, there are financial accounting and a lot of responsibilities that the court is looking to make sure that you uphold, so the individual with a disability that a guardianship is granted over is not taken advantage of in some financial or other way.
There are a range of decision-making supports available based on patients' abilities and needs. 4 types of supports will be discussed: using an informal network, designating a healthcare surrogate, guardianship, and guardian advocacy. For some young adults, informal supports may be sufficient. Consider using a network of family, friends, and social service providers. This network provides guidance and advice as the patient navigates healthcare decisions. The patient retains all medical, financial, and legal rights and responsibilities. Therefore, privacy laws still apply. Other patients may require more formalized decision-making support. A healthcare surrogate designation is a document in which the patient identifies another adult to make their medical decisions. Many providers prefer a designation of healthcare surrogate because the document is limited to one aspect of life. A healthcare surrogate has no authority to act until such time as the attending physician determines the individual lacks the capacity to make informed healthcare decisions. This may be a temporary or an ongoing state. Upon receipt of the document, providers must comply with the healthcare surrogate instructions. Medical providers may request a second opinion to confirm the patient's capacity to make decisions. Guardianship is a legal, rather than medical, determination that an adult is unable to make decisions independently. Guardianship includes identification of the guardian and the parameters of their responsibility. There are multiple levels of guardianship. Under full guardianship, all decisions are made for the patient. Under partial guardianship, the guardian makes decisions for only one area of life, such as partial guardianship for financial matters or for medical decisions. Under limited guardianship, the judge includes criteria for guardianship to expire. Frequently, judges stipulate a set time period or specific patient capacity. Limited guardianship is less common for youth with special health care needs. These are the basic steps of the guardianship process. Note that anyone can file an application. It is not limited to parents or family members. During guardianship proceedings, the judge determines competence and need for guardianship. The provider's role is to communicate assessment results, medical opinion, and supporting records. The provider assesses the patient's ability to comprehend that a decision must be made, make a plan based on their decision, and execute the plan. People with developmental or intellectual disabilities have an additional option, the guardian advocate. To use this option, the patient's disability must begin before age 18 and impair his or her decision-making abilities. Like guardianship, this process includes filing a petition with probate court, notice to the patient, and a hearing. The main difference is that this process does not include declaring the patient legally incompetent. Guardian advocacy is specifically designated for people with intellectual or developmental disabilities. Unlike full guardianship, the court automatically appoints an attorney with expertise in special needs law to represent the patient's interests. This process also offers more opportunities to waive fees. Potential guardians fill out their own application with the court to serve in this capacity. The application process includes criminal and financial background checks. Frequently, the appointed guardian is a parent, childhood caregiver, sibling, or other family member. A trusted friend or public agency can also serve in this role. The Florida Hats Transition to Go fact sheet on guardianship provides a one-page summary of this module's guardianship section. It also includes links to legal resources and service providers. Use this tool to introduce the topic with parents and caregivers or in the patient's transition plan. There are many facets to financial support and independence during transition. The next few slides introduce programs through the Social Security Administration.
Government benefits are sometimes really tricky for people to understand, and they are more complicated because they can be very different for a child who has a disability versus an adult who has a disability. A lot of parents think that everything will kind of continue status quo when our children become adults when it comes to those types of benefits, but that's not exactly the case. To qualify for a needs-based government benefit such as SSI, which is Supplemental Security Income, that's a monthly income from Social Security, and also Medicaid, which is a health insurance program for adults with disabilities, you have to pass certain tests. Not only do you have to have a disability, but you also can't have more than $2,000 in your name of countable resources. A lot of people don't realize that. At that point, families come to me and they are asking a lot of questions. Some of those questions revolve around, well, as a parent, I'm planning on, when I'm no longer here, leaving my estate, if I have a spouse, to my spouse first, and then to be divided between any children I have. If I have a child with a disability, and if in fact they might need government benefits such as SSI or Medicaid, and they can't have more than $2,000, then what do I do? The answer to that question for a lot of families could be to take a look at what's called a special needs trust. A special needs trust is a specialized legal document that assists someone with a disability in protecting any government benefits that they might need now or in the future. The money that goes into a special needs trust is actually protected from being counted as an available resource when it comes to applying for government benefits. Different states call these special needs trusts different things. Some states will call them a supplemental needs trust. Some states call them a special needs trust. It's important to know that if you have one of these documents established and you move to another state, it'd be a great idea to check with an attorney that understands special needs trust law to make sure that it is valid in your state. These trust laws can vary from state to state, and actually benefit programs for people with disabilities can vary from state to state and even county to county. The money in a special needs trust has to be spent solely for the benefit of the person who has a disability, and it cannot replace any government benefits that are out there. So for example, a special needs trust can pay for all the things that a government benefit is not already providing. I look at government benefits as providing basic needs, food and shelter. The special needs trust is a way to help enhance the life of someone who has a disability. A special needs trust can pay for things that the individual enjoys, the social types of things that cost money to accomplish that perhaps an SSI check or another benefit they're just not providing. Once that happens, when you fund a special needs trust, you would have to set up a separate account, keep an accounting of that, and make sure that the money is spent on the person who has a disability. Parents ask me, what exactly can I put into the special needs trust that I've just set up for my son or my daughter? Well, there are a lot of things that we might leave behind. We might have a home when we're gone that we want to leave to our children. Retirement plans, they could be left to a special needs trust, investments, savings accounts, those types of things. So as you're working with professionals, through the legal side with an attorney, through the financial side through a special needs financial planner, it's important to make sure that you're looking at all the different angles and how this can be done. There's no cookie cutter solution, and if there were, it would be real easy. The great thing is that families can come up with very concise plans. I would strongly encourage parents doing this planning. Please make sure that you are including the person who has a disability at the center of this planning process. The outcome will be so much better. I think it would be a wise decision as families are getting all this information with the person that they're planning for and trying to sort it out, working with someone who is experienced in the legal side of this, a estate planner. They often call themselves elder law attorneys. They're working with Medicaid and benefits and understand special needs planning and special needs.
SSI is a need-based program for children and adults with disabilities. Its benefits include monthly income and Medicaid coverage. People who may be eligible for SSI include children under 18 whose parents meet the SSI income guidelines, adults who meet medical requirements but do not meet SSDI work requirements, adults who meet the medical requirements for SSI and receive an SSDI benefit payment that is less than the SSI payment in their home state. SSDI is a need-based program for disabled adults. Its benefits include monthly income and Medicare coverage. Typically, SSDI pays benefits to workers who became disabled as adults. Workers pay into the program with every paycheck. The SSDI program also pays benefits to adults who have a disability that began before they became 22 years old. Their benefits are paid on the parent's Social Security earnings record. Children and adults with the same condition face different medical requirements. If the patient already receives SSI, then SSA reviews their medical condition when the child turns 18. Conversely, if the patient was ineligible for child benefits due to parents' income, then they may become eligible after their 18th birthday. This booklet provides information on obtaining and maintaining Social Security benefits for children. Pages 10 through 15 specifically focus on the required steps for applying for benefits when the patient transitions to adulthood. After the patient submits an application to the Social Security Administration, it goes to the State Division of Disability Determinations for medical eligibility review. In Florida, Disability Determination Services is part of the State Health Department. After that process is complete, they return the application and their findings to the Social Security Administration for a final determination of eligibility. Disability Determination Services will likely interview the parent and review documentation. The parent may provide information on the medical condition, dates of medical appointments and hospital visits, releases of information to specific providers, and copies of medical reports or information from their own records. Determination Services or Social Security may independently contact healthcare providers, teachers, daycare providers, or other family members. They may also request school and medical records. Their goal is to gather information about how the patient's disability affects their activities of daily living. Like guardianship, the provider's role is not to make determination, but to provide medical opinion, assessment, and records. A diagnosis alone is not enough information to verify the patient's functional capacity. Determination Services, Social Security, or the family may request documentation from your practice that demonstrates how the condition-specific symptoms affect day-to-day tasks. The final stage of adolescent development is interdependence. This is true for all patients. For some patients, this will include personal care attendants who carry out physical tasks. For others, it will include a healthcare surrogate or guardian who supervises medical care. For many, it will include the support of their parents, caregivers, siblings, and friends. Recall the 8 steps of the transition process supported by the Joint Statement on Transition, the 6 core elements, and the Florida algorithm. Addressing legal and financial considerations is a key part of the final two steps in the transition process. If you begin with regular assessment and planning around age 14, then the patient and family will be prepared for program referrals. Rows 3 and 4 in the Florida algorithm outline specific program requirements and steps to take at specific stages. Address legal and financial considerations as part of the healthcare transition plan. Include discussions on confidentiality, consent, decision-making capacity, and social service programs for adults. Like all transition plan areas, add age-appropriate items to the plan and gradually build towards the 18th birthday. Parents need good information to explore all options and make the best possible decision. Encourage parents to discuss these issues with their child to the greatest extent possible. For patients with limited decision-making capacity, try less formal supports before the legal responsibilities are attached. Remind the patient and family that practice is key to success. Include steps for developing and maintaining such a network in the healthcare transition plan. Include guardianship steps as part of the healthcare transition process at age 16. This allows time for the family to find legal advice, gather documentation, and complete the process before the patient's 18th birthday. Consider the existing transition activities, assessment, and planning beginning at age 14. At what age will you introduce guardianship or Social Security with parents and families? How will you prepare parents and patients for these changes? This slide will automatically advance in 1 minute, giving you time to jot down your answers to the questions on this screen. Before closing this module, we will review the resources for use in your practice. Disability Rights Florida offers many resources to educate patients and families on guardianship and alternatives to it. The Ticket to Work website provides information on how to participate in the program, who is eligible, how to maintain Medicaid and Medicare coverage while using Ticket to Work, and a fact sheet on the program. The Social Security's Plan for Achieving Self-Support program website gives information on benefits, how to participate, and eligibility. ssa.gov/disability-SSI provides the news and information on the program. Patients can use the website to complete the application, check the status of their application, or manage their benefits. The FDDC provides a comprehensive guide to housing resources for people with developmental disabilities. The Florida Transportation Disadvantaged Program is a coordinated statewide effort to provide shared ride services in all 67 counties. The program serves anyone who cannot independently access transportation due to income, age, or disability. The Florida Alliance for Assistive Services and Technology, or the FAST, created this guide for accessing the Transportation Disadvantaged Program. When addressing legal and financial considerations, there is a wide range of supports and options for the patient. Use the transition plan to complete specific requirements and start early. Use the links from this course's toolkit to access the resources from this module. Legal and financial considerations have a significant impact on the next topic, health insurance. You can pause the presentation to take a quick break or automatically continue to the next module.